I used to believe that the work spoke for itself, that if you designed something truly original, something that fused creativity with functionality so seamlessly it felt inevitable, people would respect it. My name is Elias Novak, and I'm an industrial designer. Not a celebrity in my field by any means, but I had quietly made a name for myself in sustainable product design. My studio was a single, sunlit room above a printing shop on the east side of town, with uneven floors and a ceiling fan that wobbled when it turned. But it was my sanctuary. For months, I had been working on a concept that kept me awake at night, a collapsible, modular furniture system for micro-apartments, a hybrid of Scandinavian minimalism and rugged adaptability. It wasn't just a product. It was an answer to a problem I understood personally: how to make limited spaces livable without turning them into storage closets. By the time I finished the prototypes, they looked almost impossibly clean. A dining table that folded into a wall panel, a sofa that transformed into a bed without the awkward bulk of a futon. Every joint, every mechanism felt like a small victory. My mentors at design school had always told me good design is invisible when it works. It worked. I took a risk and filed for a design patent, a costly move for someone like me, but one I knew was necessary. That's when I got the email. The subject line read, "Proposal for collaboration, Rourke Interiors." Rourke was one of the largest furniture corporations in the country, known for their bold branding and relentless expansion. At first, I felt flattered. Me, a one-room studio designer, on their radar? It was surreal. They requested a presentation, said they were, quote, very interested in my ideas. I spent 2 sleepless nights perfecting my pitch, imagining what this could mean. A partnership, resources, maybe even seeing my design in homes across the country. But when I walked into their towering headquarters, surrounded by their glassy confidence and corporate smiles, something in my gut twisted. They listened, nodded, asked pointed questions, but I caught the way one of their executives, a man named Harrington, their VP of Product Development, kept glancing at his watch like I was an inconvenience. When I left, I told myself I was overthinking it, that maybe this was how big corporations worked. Cold, calculated, efficient. A month passed. No deal. No follow-up. My emails went unanswered. I buried my disappointment and went back to work, chalking it up as a missed opportunity. Then one evening, scrolling through social media, I froze. There it was, a flashy new product line by Rourke Interiors. They called it the FlexiSpace Collection. My designs, my collapsible table, my modular sofa. Every detail, down to the placement of the wall mounts and the folding hinges, replicated. My heart pounded as I stared at the images, bile rising in my throat. They hadn't just stolen my idea, they'd stolen my work, gutted it of its soul, and branded it as their own. That was the first time I understood how deeply naive I had been. The night I saw the FlexiSpace Collection announcement, I barely slept. My mind kept replaying every moment from that meeting at Rourke. Their polite smiles, their requests for detailed sketches, the signed NDA I had so carefully prepared and watched them review without a second thought. I remember leaving their office that day believing I'd done something right, that my work had value to them. Now I saw it clearly. I had handed them everything they needed on a silver platter. By dawn, I was pacing my apartment with a notepad in hand, writing down everything I could remember from our interactions. Times, dates, names. I dug through my emails, printing every exchange. The NDA was my anchor. I kept rereading it like a lifeline, clinging to the belief that it would protect me. But as I started looking into Rourke's history, I realized just how monstrous they were. This wasn't the first time they'd been accused of borrowing independent designers' ideas. I found forum threads, angry blogs, even a half-buried lawsuit from years ago that ended in a quiet settlement. They had done this before, and they had gotten away with it. I took a deep breath and called their legal department. My voice trembled, but I kept it steady. I need to speak to someone about the FlexiSpace Collection. There's been a violation of my intellectual property. They transferred me to a lawyer who sounded bored before I even introduced myself. I could almost hear the smirk in his voice when he said, "Mr. Novak, I assure you, our company operates with the highest integrity. Any similarities are purely coincidental. I hope you understand these designs are standard in the industry." He hung up before I could even finish my protest. It felt like being punched in the chest. I tried to tell myself I was overreacting, but the more I analyzed their collection, the more I saw my fingerprints on every component. They hadn't even bothered to change the locking mechanism I had spent weeks refining. That wasn't coincidence. That was theft. And their arrogance, dismissing me as if I were just some noise they could ignore. lit a fire I didn't know I had. I went to a local attorney, a gray-haired man named McCleary, who had handled a few intellectual property cases. He listened patiently as I explained, laying out my sketches and patents. When I finished, he steepled his fingers and sighed. "Elias, I'll be honest, you're up against a giant. These cases take years, cost a fortune, and companies like Rourke are experts at dragging them out until people like you give up." His words stung, but he didn't tell me to quit. He leaned forward. "Do you have proof they had access to these designs? Emails? Presentations? Prototypes?" I slid the NDA and my pitch materials across his desk. He raised his eyebrows. "Well," he said after a long pause, "this changes things." Even with McCleary's cautious optimism, the weeks that followed were brutal. Filing the lawsuit drained my savings faster than I could comprehend. Every letter from their lawyers was a weapon designed to intimidate me. They called me a fraud. They accused me of defamation. They tried to paint me as some desperate nobody trying to exploit their success. There were nights I sat in the dark staring at their countersuits, feeling like I was losing myself to a war. One hadn't wanted to fight. Then came the public attack. A well-known design blog published an, quote, exclusive interview with Harrington, the VP who had sat across from me in that meeting. In it, he praised his team for months of research and development on the FlexiSpace line, claiming it was entirely original work. The article didn't mention me by name, but it included veiled digs about designers who try to claim ownership of common ideas. It felt like they were daring me to break, but I didn't. Instead, I started documenting everything like my life depended on it, because it did. Every social media post they made about their collection. Every advertisement that used my designs. I photographed my prototypes with timestamps. I dug out my original sketches from their dog-eared notebooks. I wasn't just building a legal case anymore. I was building an unshakable wall of truth. Still, their reach was suffocating. I lost 2 potential freelance clients who suddenly couldn't afford to move forward. My landlord hinted that Rourke reps had been asking questions about me. Friends advised me to take a settlement if they offered one, but I knew what that meant. Silence. Signing away my rights. Letting them win. I refused. And then, just when I felt like I was running out of air, something unexpected happened. An anonymous email landed in my inbox. "I know what they did to you. I was there. We need to talk." No name. No phone number. Just a burner email address and a promise that made my hand shake as I reread it. At first, I thought the email was a cruel joke. A setup. Rourke was known for playing dirty, and paranoia had become second nature to me by then. But something about the message felt desperate, like the kind of thing you write when you're at your breaking point. I responded cautiously, keeping my reply short. "If this is real, prove it. Meet me in person, somewhere public." They agreed. 2 days later, I was sitting in the corner of a crowded cafe, my pulse pounding as I scanned every face that walked in. She was younger than I expected, maybe late 20s, dressed in an oversized coat and a cap pulled low. She slid into the chair across from me, keeping her voice low. "My name doesn't matter. I worked in product development. Harrington was my boss." She glanced around, then placed a flash drive on the table. "These are the internal emails, project notes, even the original CAD files. Your designs weren't just inspiration, they were the blueprint. They used your work as the foundation for the FlexiSpace line, and Harrington ordered us to scrub any reference to you from the records." My throat tightened. "Why are you doing this?" Her gaze was steady, but I could see the exhaustion in her eyes. "Because I'm done working for thieves. And because what they did to you isn't unique. I've watched them steal ideas from others, too. You just happened to be the one who fought back." She stood before I could say more. "Don't try to contact me. If anyone finds out I gave you this, I'm finished." I stared at the flash drive in my hand for what felt like hours after she left. When I showed the files to McCleary, his reaction was immediate. "This is the smoking gun," he said, flipping through the chain of emails where Harrington casually instructed his team to incorporate Novak's folding mechanism verbatim and replace my name with in-house conceptual drafts. There were time-stamped attachments, my presentations, sitting in their servers. I felt my stomach twist when I saw my diagrams, my handwriting, living inside their network like stolen organs in a new body. For the first time since this nightmare began, I felt something sharp and grounding. Control? McCleary leaned back in his chair. This changes the entire landscape. They can't claim coincidence now. This is willful infringement, and with these communications, possibly even fraud. We'll amend the lawsuit. We'll push for discovery. And if they try to bury this, we'll take it public. But I didn't want to just win in court. I wanted them exposed. I wanted their carefully manufactured reputation as, quote, innovators torn apart. That night I sat in my tiny studio, surrounded by sketches and notes, trying to calm my racing thoughts. I thought about why I had become a designer in the first place. It wasn't for money or recognition. It was to solve real problems in ways people hadn't thought of before. That mattered more than anything Rourke could take from me. But the realization cut deeper. If they could get away with doing this to me, they would do it to others. They already had. I needed a strategy that did more than protect me. It had to dismantle the myth of Rourke's integrity. Step 1. Solidify my evidence. McCleary and I hired a digital forensics specialist to verify the authenticity of the files. Every email, every timestamp was preserved in a way no jury could question. We collected sworn affidavits from colleagues who had seen my prototypes months before the Rourke meeting. I recorded my own timeline of events, detailing every interaction with their team. Step 2. Leverage the public. I reached out to the same design blogs that had published Harrington's glowing interviews. I didn't give them everything, just enough to hint that a storm was coming, that I had proof of Rourke's theft. Some ignored me, but one independent journalist, a woman named Talia Rivera, responded. If you have evidence, she wrote, I'll tell your story, but be ready. They'll come after you harder than ever. Step 3. Prepare for war. McCleary called it controlled aggression. Rourke had counted on my silence. Now I would force them to respond on my terms. We filed a motion for expedited discovery, demanding full access to their internal project records. At the same time, Talia's article hit the web, a blistering piece titled Theft in Plain Sight, How Rourke Interiors Exploits Independent Designers. She didn't name me directly, but the timing was no accident. The industry noticed. Whispers started spreading in forums and trade groups. For the first time, Rourke was on the defensive. Harrington called me. I'll never forget the smugness in his voice as he said, You're making a big mistake, Novak. We could have settled this quietly. But if you want to drag it out in public, fine. Just know we always win. I didn't flinch. You haven't faced me yet. After I hung up, I sat in silence for a long time. My hands were shaking, not from fear, but from a strange, overwhelming clarity. This wasn't about salvaging a career anymore. This was about taking everything they thought untouchable and forcing them to watch it crumble. The plan was set, and for the first time, I felt ready. The first hearing felt like stepping into another world. Rourke's legal team arrived like a small army. 3 sharp-suited lawyers and 2 paralegals who wouldn't even meet my eyes. Their lead counsel, a man named Donovan Price, exuded the kind of practiced arrogance you only get after decades of bullying smaller opponents into submission. He smirked when he saw me sitting next to McCleary in my plain Navy suit like I was a child who'd wandered into a game for grown-ups. But when McCleary presented the motion for expedited discovery, anchored by the flash drive evidence, sworn affidavits, and a detailed timeline, the smirk faltered. Donovan objected, of course, painting me as a, quote, disgruntled freelancer attempting to weaponize confidential corporate correspondence. But the judge wasn't buying it. She ordered Rourke to hand over their project records within 30 days. It wasn't a win, not yet, but it was a crack in their armor. Those 30 days were brutal. Their lawyers bombarded me with interrogatories, demands for proof of every claim I'd made. They subpoenaed my financial records, my emails, even my old college portfolios, digging for anything to discredit me. They wanted to overwhelm me, break me down before the real fight began. But every time I felt that panic creep in, I reminded myself of the woman in the cafe, of what was at stake. The real breakthrough came when the discovery files arrived, tens of thousands of pages of internal emails, memos, and design documents. It took weeks to sift through them, but what we found made my stomach churn and my resolve harden. There were internal presentations with my sketches, some still bearing my signature in the margins. Emails where Harrington instructed his team to, quote, sanitize any external references to my work. Budget notes allocating resources for, quote, rapid prototype integration from Novak Concepts. It wasn't just theft. It was deliberate, coordinated, and systematic. McCleary's office became a war room. Charts covered the walls, connecting dates, names, and directives. This, McCleary said, pointing to one email chain where Harrington explicitly told his assistant to, quote, handle Novak if he becomes an issue, is the nail in their coffin. While the legal side escalated, I executed the second prong of my plan, public pressure. Talia Rivera's follow-up article went live, this time with my name. She didn't mince words. Independent designer takes on Rourke Interiors in landmark IP theft case. She published excerpts of the emails, carefully vetted by McCleary to avoid breaching confidentiality. The piece went viral in design circles. Within days, other independent creators began sharing their own experiences with corporate exploitation, some naming Rourke directly. And then, like a spark in dry grass, the story spread. Industry influencers shared it. Design podcasts discussed it. A popular YouTube channel dissected the FlexiSpace line side by side with my original prototypes, exposing the similarities in front of millions. Rourke's social media pages flooded with comments, "Thieves, pay Novak, boycott Rourke." Their PR team scrambled, issuing a sterile press release denying, quote, all allegations of wrongdoing. It only made them look worse. Behind closed doors, settlement offers started arriving. First, a modest payout, then a bigger one, tied to a non-disclosure agreement. "Take the money, Elias," McCleary said, reading the second offer. "It's more than most people ever get." But I couldn't. Settling quietly would mean they kept their brand, their illusion of integrity. They'd just do it to someone else. "I'm not here for a payout," I told him. "I'm here for accountability." The next phase was depositions. Sitting across from Harrington, watching him squirm as McCleary read his own emails aloud was surreal. He tried to play it off as, quote, industry-standard collaboration, but the contradictions piled up. When asked why my designs appeared in their internal files months before their supposed original development process, he deflected, stammered, looked to Donovan for help. Afterward, McCleary leaned toward me and whispered, "He's cracking." But the real turning point came from the woman in the cafe. Through McCleary, she agreed to give a sworn statement under whistleblower protections. Her testimony laid everything bare: the deliberate erasure of my authorship, the internal discussions about how to discredit me if I pushed back, even the intimidation tactics Rourke used to keep employees silent. It was devastating for them. As the trial date approached, I felt an unexpected calm settle over me. For months, I had been reacting, scrambling to survive their attacks. Now I was on the offensive. I wasn't just fighting for my design anymore. I was fighting for every creator who'd been told they were too small to matter. Donovan tried one last stunt, a motion to dismiss based on lack of substantial originality, essentially claiming my designs weren't unique enough to protect. The judge denied it. In her ruling, she wrote, "If Mr. Novak's work lacked substantial originality, Rourke Interiors would not have built an entire product line upon it." Reading that line felt like breathing for the first time in months. The plan was working. The walls were closing in on them. And I knew. I could feel it. The real reckoning was coming. The trial began in a courthouse that felt far too small for the storm it was about to hold. The gallery was packed. Journalists, industry insiders, and a handful of young designers who'd been following my case online. Some nodded at me as I entered, silent messages of solidarity that anchored me in place when my legs wanted to give out. Rourke's team arrived like they owned the room. Harrington in an immaculate suit. Donovan Price leading the charge. Their paralegals trailing behind carrying boxes of neatly tabbed binders. I noticed how Harrington avoided looking at me, his chin tilted just high enough to feign indifference. When I took the stand, my heart pounded in my ears. I had rehearsed this testimony 100 times, but nothing prepared me for the weight of their eyes. The jury's, the press's, Rourke's. McCleary guided me through the timeline. My design process, my meeting at Rourke headquarters, the NDA, the aftermath of seeing my work repackaged as theirs. I spoke slowly, deliberately, refusing to let emotion muddle my words. I trusted them, I said at one point, glancing toward Harrington, and they saw that trust as an opportunity to take what wasn't theirs. Then came the evidence. McCleary projected the internal emails onto a large screen, the jury leaning forward as he read them aloud. Incorporate Novak's folding mechanism verbatim. Remove any external attribution before final drafts. Seeing those words in black and white, hearing them echo through the courtroom was electrifying. My designs, my signature sketches, appeared in their project files, still bearing my handwritten annotations. Donovan objected to nearly everything, his voice rising with frustration, but the judge overruled him again and again. And then came the witness. The young woman from the cafe took the stand under whistleblower protections. I watched Harrington's jaw tighten as she described the internal culture of silencing dissent, the explicit instructions to erase my name from their files, and the conversations about how to neutralize me if I became a problem. She didn't flinch. Her words cut through the room like glass, and for the first time, I saw genuine fear in Harrington's face. Donovan's cross-examination was vicious. He tried to paint her as a disgruntled ex-employee, someone with an axe to grind. But she held her ground. "I left because I couldn't keep watching them exploit people," she said, her voice steady. "And Elias Novak isn't the first." That last sentence landed like a blow. The gallery murmured, the judge banged her gavel for silence, and I caught Donovan scribbling something furiously on his legal pad. In his closing arguments, Donovan tried to spin the case as a misunderstanding, that my work was inspiration, not theft. That modular furniture was a, quote, non-protectable concept, but McCleary dismantled every point with surgical precision. "If it was just a concept," he said, addressing the jury, "why did they use his exact mechanisms, his exact designs, his exact innovations? Why did they erase his name? Why did they hide the paper trail?" The jury deliberated for 2 days, 2 of the longest days of my life. I barely slept, pacing my apartment, reading and rereading the whistleblower's testimony, my own words, the judge's instructions. Every possible outcome spun through my head. What if they settled behind closed doors? What if the jury believed their narrative? What if I had destroyed my life for nothing? On the 3rd day, the courtroom filled again. I sat rigid, my palms sweating as the foreperson stood to deliver the verdict. On the count of willful infringement of intellectual property, we find in favor of the plaintiff, Elias Novak. The air left my lungs in a rush. The foreperson continued, "We award damages in the amount of $15 million, plus punitive damages in the amount of $10 million. My mind couldn't fully process the numbers, but I caught the collective gasp from the gallery. Rourke wasn't just losing, they were being gutted. But the real blow wasn't financial. Within hours, the story went everywhere. Jury rules against Rourke Interiors in landmark IP theft case. Their stock price plummeted. Industry blogs called for boycotts. 2 major retailers announced they were discontinuing Rourke products, citing, quote, ethical concerns. The board of directors moved quickly, announcing Harrington's resignation, effective immediately. But it was too late. Their brand, once synonymous with innovation, had become a cautionary tale of corporate greed. When the verdict was read, I didn't cheer, I didn't cry. I just sat there, staring at my hands, feeling a strange mixture of relief and emptiness. This wasn't triumph in the way I'd imagined. It was something quieter, heavier. Justice didn't erase the sleepless nights, the doubt, the humiliation. But it mattered. It mattered more than I could put into words. As I left the courthouse, the young woman who'd risked everything to help me was waiting by the steps. She didn't speak. She just nodded. A silent acknowledgement that this fight had been about more than me. And I nodded back. I had taken on a giant. And I had won. In the weeks after the verdict, my life transformed in ways I hadn't anticipated. Reporters called non-stop, asking for statements, interviews, exclusive insights into, quote, how a lone designer toppled a corporate empire. Overnight, I became a symbol, not just a guy who fought for his work, but a representative of every small creator who'd been crushed by a machine too big to fight. It was strange, almost surreal, to see my name in headlines and on industry panels. A few called me a hero, but I didn't feel like one. I felt like someone who'd been dragged through fire and somehow crawled out intact. The money changed things, of course. $15 million in damages plus the punitive award, numbers I still couldn't fully grasp, meant I could rebuild my life without fear of the next rent payment, the next unpaid invoice. But it wasn't the number that mattered most. It was the acknowledgement. The validation that what they did to me wasn't just business as usual. It was theft. It was wrong. And the world had seen it for what it was. Rourke never recovered. Within 6 months, 3 board members resigned. Their stock value kept sliding, and competitors circled like sharks. The FlexiSpace line, the crown jewel they'd stolen from me, was quietly discontinued. They tried rebranding, but it didn't matter. The story had stuck. They weren't innovators anymore. They were thieves. Harrington disappeared from the industry altogether. I heard whispers that he'd moved overseas, but I didn't care enough to find out if it was true. The whistleblower, the woman who'd risked everything to come forward, stayed in contact through McCleary. I never learned her full story, but I made sure part of my settlement went toward her legal protections and helping her land on her feet. Without her, none of this would have been possible. She had given me more than evidence. She had given me the courage to keep fighting when I wanted to give up. As for me, I moved my one-room studio into a proper workshop. Tall ceilings, natural light, a space worthy of the work I wanted to create. But I didn't jump back into designing right away. For months, I just sat with everything. The fight had taken so much from me. My peace, my naivete, my belief that good ideas could simply exist without being preyed upon. I needed to find myself again before I could make anything new. When I finally did return to the drafting table, it wasn't to design furniture. It was to create something bigger, a foundation. I used part of the settlement to establish a legal aid network for independent creators, a place where designers, artists, and innovators could get real, affordable protection for their work. I called it Anchor, because that's what I wished I'd had when I was drowning. People asked me if I regretted not taking one of Rourke's early settlement offers. If I regretted the sleepless nights, the public fight, the bruises to my soul, my answer was always the same: no. If I had taken their money and stayed quiet, they'd still be out there doing it to the next person. My silence would have been their weapon. I learned something in that courtroom, in those months of legal battles and late-night strategy sessions. Real power isn't just in the design, the invention, or the creation. It's in refusing to let someone take it from you without a fight. It's in standing up when every instinct tells you to stay small, stay silent, stay safe. Sometimes the world underestimates people like us, the independents, the small voices, the ones working from studios above printing shops. They think we'll fold. They think we don't have the stomach for the fight. And maybe that's what made my victory so devastating to them. They never saw me coming. And now I tell every young designer who writes to me, scared of having their work stolen, the same thing. Your ideas matter, and you matter. Protect them. Fight for them. Because no one else will. That's the legacy I wanted. Not just a verdict, not just a victory, but a reminder to every creator out there. We are not powerless.